A brilliant idea is fragile. To turn a raw concept into a legally protected asset, it has to be locked down. Contrary to popular belief, there is no single worldwide patent. Protection stops exactly at national borders. If you want exclusive rights in a specific country, you have to fight for them under that country's specific laws. This blueprint shows the global patent lifecycle across 3 strict phases. Phase 1 is the construction zone. Phase 2 is the inspection zone, where examiners scrutinize the filing. Even if you survive, Phase 3 means actively defending your granted patent in the open market. Patents are not handed out because an invention is clever. They are rigidly constructed, heavily inspected, and require constant maintenance to stay valid over their 20-year lifespan. In the Indian patent system, that theoretical blueprint quickly becomes a mountain of rigid paperwork and strict deadlines. Before filing, you document the mechanics of your invention using an invention disclosure form. From there, you search databases like InPass to ensure your idea is actually novel and hasn't been claimed before. This timeline shows 2 paths. Take Path A, a provisional specification, to lock your priority date, or take Path B, filing a complete specification immediately. The provisional route starts a countdown. You have exactly 12 months. On day 366, it's abandoned, permanently losing your priority. This exploded diagram shows the administrative payload: Form 1 for application, Form 2 for technical specifications, Form 3 for foreign filings, Form 5 for inventors, and Form 28 for entity type. Your entity type dictates fees, 1,600 rupees or 8,000 for large entities. An early priority date offers no protection if the applicant fails to submit the required forms or misses a single statutory deadline. Once filed, your application begins a 10-step journey. After an 18-month wait, the invention is published. You then have 48 months to file a request for examination, or the application is withdrawn. Once examined, a first examination report issues, requiring you to actively defend your claims. You typically have 6 months to respond. If objections remain, you attend a formal hearing. Only after satisfying the examiner do you secure the final grant, which then requires annual renewal fees to stay alive. An application expires by default in India unless you force it forward, request examination, and actively defend your claims. Surviving examination and receiving a grant certificate does not mean your invention is permanently safe. The system includes ongoing control mechanisms. Competitors and the public can file a pre-grant opposition to stop the award, or a post-grant opposition within 1 year of publication to challenge its validity. The ultimate threat is Section 64 revocation. This legal process destroys an existing patent, returning the invention to the public domain. A patent is revoked for fatal flaws, including lack of novelty, prior secret commercial use, or concealing foreign filing details from the patent office. The stakes are absolute. A revocation petition has no statutory time limit. It can be filed even after the patent has expired, retroactively destroying its value in an infringement suit. A patent exists in a constant state of defense against competitors, the market, and the law. Transforming a raw idea into a monopolistic asset requires enduring a grueling timeline of global rules and intense Indian regulations. To understand exactly how the public can challenge your asset, watch our deep dive video covering the mechanics of patent oppositions and how to survive them. A patent is an engineering achievement, but its survival depends on a 20-year commitment to legal defense.